Hello, everyone. I am Diane Donnelly, and I am with the Donnelly Group of Keller Williams Flagship of Maryland. And welcome to the Donnelly Group TV. Today we are going to be talking about part 2 of a 4-part series on estate planning. Last week we talked about dying with or without a will. And today we're going to talk about blended families and some of the considerations that you need to consider that you may not have thought of. And the third thing next week, the following week, we're going to be talking about guardianships, and that's when a person is no longer able to make decisions on their own and what happens and what the process is from that point. And then October 28th, we're going to talk about asset protection. And with us today, we have Tara Frame. And Tara, if you would tell us a little bit about yourself, everybody would love that.
Hi, thank you for having me again this week. My name is Tara Frame. I'm an attorney with Frame & Frame. We have been in business since 1954 when my father opened the practice, and my practice focuses primarily on estate planning, elder law, probate and estate administration, and guardianship. And yeah, we really make an effort to try to educate families and people about their estate planning options and make sure that they're adequately protected.
And I want to thank you again. I know I say this every week, but every week when we are planning what our next topic is going to be, and I do a little bit of research, I learn something every single time. And some of today that we're going to talk about floored me, some of the information that I was reading about for today's topic. So thank you for that.
Sure.
Yeah. So I'm going to do something a little different. I'm going to read a scenario, and then you tell me what the challenge is with the scenario, okay? And in terms of blended families, what things people need to consider. So the first one is a couple of stats, first of all. 50% of marriages end in divorce, and 60% of remarriages end in divorce. Okay, so that's just a statistic to keep in mind as we go into the next question here. So situation 1, Bob and Karen have been married for 15 years, and it's the second marriage for both of them. Bob and Karen both have 2 adult children from their previous marriage and a 13-year-old daughter together. They did their due diligence and they did their estate planning, and they have a simple will that leave the estate to the surviving spouse. Bob has a heart attack and passes away. Karen moves closer to her children and becomes estranged from Bob's children. She changes her will to give her entire estate to her 2 biological children. Tara, what's the problem here?
First of all, you have a little piece of paper in your camera.
I do? You can see my little note there?
I'm like, sorry.
Is it gone now? Were you staring at it the whole time?
I was.
Well, thank you for telling me.
No problem. Yeah, so no, that's an interesting situation that comes up all the time. So, you know, I have people come into my office and they say, you know, we just need a simple will. I'm going to leave everything to my wife. And then if she dies, she's going to leave everything to me. And then we're going to leave everything to you. So, you know, that's fine. And it sometimes happens that way. It happens the way they're intending. But a lot of times, and I would say the majority of instances, that does not happen. Because what happens is you have one spouse passing away, everything goes to the surviving spouse, and like in this situation, you know, life happens, circumstances happen. You know, the decedent's, the husband's children don't keep in touch with the wife, and then all of a sudden she has 100% of the assets, and when she's ready to get her affairs in order, you know, she's going to leave everything to her children. Or, you know, I have people that they have every intention of dividing everything with all of the children, you know, her children and the stepchildren. But then you have her children, you know, talking in her ear here and there, and then unduly influencing her. Say, well, why should they get any part? Mom, this is your money. You can do whatever you want with it. And then mom feels obligated to change the estate plan to leave it all to her children. So, so we have these discussions, and I go over these various scenarios, and when people start listening to, okay, what about in this situation? You know, I see their eyes bulge and say, oh my gosh, you know, we never thought about that situation. So we go over the various scenarios, and one way to avoid that is by the use of trusts. So we can, you know, we can create trusts such that when one spouse dies, I'll just give you an example. Half of the assets go into his husband's trust and half goes into wife's trust. Wife can do whatever she wants with her trust money. She can spend it, she can get remarried, she can leave it to, her new spouse, she can leave it to charity, whatever. But the husband's money in his part of the trust cannot be taken out by her. It can still be there for her health, education, maintenance, and support. So it can be used for her benefit if need be, but she can't just go take out all that money and divert it to herself and her family. And then when she dies, that guarantees that husband's part of the marital monies, the estate, is going to make its way down to his children. And then when wife dies, her part is going to make its way down to her children, if that's what they've decided. So, after he dies, she can change her mind with her part, but she can't change his part. So, it becomes irrevocable with regard to the decedent's portion of the estate plan.
Well, that seems like something that would be really important, and something most people would not consider. That to me, I would think that I'd write out my will and everybody knows what my wishes are, and that's what's going to happen. But in this situation, it's so easy to be changed by the surviving spouse, which may, likely in this scenario, that wasn't Bob's intention. His intention was not to estrange his children and keep all the marital money and let that go to hers.
Right. And I'll tell you, people say, oh, that doesn't, that wouldn't happen. I will tell you, I had a client come in last year and he was dealing with cancer. He and his wife created their wills, and I went over the scenarios with them, but they decided they just wanted wills. So when he passed, everything went to his wife. And unfortunately, she called my office not 2 weeks after he died to let me know that she had a new will that she created, leaving everything to her children, and disinherited his children completely.
Wow.
And that was 2 weeks after his funeral.
Wow.
So those are the situations where, and it really destroys families, because even if you have step family, stepchildren or step parents, if you want to maintain those relationships, that is definitely not the way to do it. So, it definitely causes resentment. Sometimes it leads to lawsuits. Whether they're successful or not, is a different story, but it really causes disharmony in the family, creates a lot of resentment.
No doubt.
Hatred between people and family members in that type of situation.
And I want to reiterate that Bob's intention is not being carried forth here, even though he had his simple will. And when we do a recap, so there are situations that simple wills will not cut it. Just not gonna, it's not appropriate for that situation. And that's why I'm glad we're doing blended families, because with 50% going into divorce and 60% of remarriages going into divorce, these are real things. This is real life. This is half of the people. These considerations are applicable to half of the people who get married.
Yes. And that's they just, and I don't expect them to think of these scenarios and know, what happens if then, if this, then what. So, unfortunately, they're just oblivious to what's going to happen or what could happen. So that's why, we really, things like this, these webinars, we're able to educate people and let them know that there are strategies, there are solutions to solve these problems, and to, give you peace of mind that things are going to be carried out the way you want them to when you're gone, and you're not just kind of leaving it to chance or trusting a family member to do the right thing.
Yeah, and I think it's important too for people that are stressing out, saying, "Oh, I would never want to think that way about my loved one." I think that people should think about it as, I just want to be sure that my intent is carried forward, so that there's no undue pressure on anybody at any point. So here is my intention, and let's make sure through a trust that it's going to be carried out exactly as I plan when I leave this earth.
Exactly.
Right? Okay, let's talk about situation number 2.
Okay.
Ralph is a widower, and he is 56 years old, and he marries Lauren, who is only 27 years old. Ralph has 2 children from his previous marriage, and he wants to provide for his wife, but he does not want to risk his children being disinherited as in the previous situation. He creates a trust that names his two children as remainder beneficiaries, and then Andy dies, and his children become resentful at having to wait until Lauren's death, who's only 27, to receive their inheritance. What's wrong with this?
Yeah, I mean, there's a lot wrong with that too, because I mean, first of all, you know, he wants to care for the children, he wants to care for the wife, but the wife is so much younger than, you know, I mean, these children might be waiting 30, 40, 50 years before they ever see the money, if they ever saw the money. So, you know, the nice thing, again, with a will, you can't really solve this problem. This would also be using trust. So in this type of situation, the beauty of a trust is you can be really creative. You can do so many things in a trust that you can't really do in a will, because when you have a will and someone dies, it goes through the probate process. Assets are, you know, accounted for, they're distributed, and they're conveyed to the heirs. Once that's done, the estate is closed. There's no oversight. It's done, right? When you have a trust, you're always going to have a trustee. So as long as there's something to be done with the trust funds, you're going to have a trustee in charge to make sure everything's handled properly. Distributions are made as instructed by the trust maker, and that you know, those intentions are carried out. So in this situation, you know, probably my recommendation would be, if that was a concern, that, you know, maybe we could, you know, either leave 50% to the spouse, and that would care for her for the rest of her life, and then when she dies, it goes to the children, and then do a 50% distribution to the children immediately upon death. Or you could give the children, you know, 1% distribution per year for until the wife dies. Or, you know, we could say, well, maybe I'll give them $10,000 a year until the wife dies. So there's lots of different scenarios. Really can be as creative as you want to. You know, you could, I often do distributions at ages or intervals. So if you had a portion, you know, everything being held for the wife, and she could, that's for her, you know, her maintenance and support. And maybe the children's portions paid out, you know, each of them get a share, and then it gets paid out 25% when they're 40, 25% when they're 45, 25% when they're 50, and then the rest when they're 55. So there's lots of things you can do. And that's the part that I really enjoy, is being kind of creative and coming up with the solutions to these different scenarios. So it's not like I'm putting names in a computer, pushing a button, and out spits the same document for everyone. Like if you do it yourself, one of the, you know, do it yourself software programs online, you know, these, you really have to give it some thought to, and what happens if this, and what happens if that, and you want to design and craft the provisions so that, you know, the client's concerns are addressed, and they, you know, are comfortable knowing what's going to happen when they're no longer here.
Right. Is it possible in an estate, I mean, in a trust, to be able to say, if then I want this, or in this case? So for example, if somebody got remarried, and a husband says, okay, if she gets remarried, I want this to happen. And if she is not married, I want this to happen. Is that possible to say, you know, give different scenarios that may or not happen?
Yeah, you definitely can, because, and the only issue with that is you have to be really careful as to who's going to be the trustee. Because if, you know, the surviving spouse is the trustee after you're gone, she potentially could have a lot of discretion to distribute as much as she wants, and then you don't want to have the remainder beneficiaries, the kids who are ultimately going to receive, have a controversy with the surviving spouse, the stepmother. If you want to avoid those scenarios. But yeah, you certainly can put conditions. In a lot of my trusts, I have provisions that prevent trustees from, gets into a little bit of the asset protection conversation, but preventing children from getting distributions if they're a drug abuser, become a substance abuse issue, if they some of them join a religious cult and they get involved in something that the parent, doesn't want them to, or if they don't finish their college education, one of the conditions can be you have to complete your college education and get a 4-year degree, or at least a vocational training and start a career before you're entitled to money. So there's lots of things we can do, and like I said, we can be really creative.
That's really good. Those are good considerations. I want to give one more scenario. Is that okay? Okay. What if one spouse has significantly more assets than the other spouse, and they want to be sure that their children are cared for, and not lost in the mess after they pass away? So what should people consider if one of the people have more assets than the other?
So in that scenario, what I would generally use would be a 2-trust plan. So, for example, we would take all of husband's assets and put it in his trust, the husband's trust. We would take up all of the wife's assets and put it in the wife's trust. If there's joint assets, we can decide where we want to put it, or we can split it up 50-50. We often have those scenarios. And then, wife has her use of all of her money to do whatever she wants with. Husband's money would be there for her, maintenance and support during the rest of her life, if that's what he wants. And then eventually all of his money would make it down to his children.
Yeah, go ahead. I'm going to ask one more question after you had a thought.
I was just going to say, sometimes I have, wife has 2 children, husband has 2 children, and then they have one, together. So in that scenario, wife might leave the remainder of her trust to her biological 3 children, and he's going to leave it to his 3 biological children, one of which is their shared child.
Okay. That's interesting. So how do you decide whether a person is a simple will do it, or if we're talking about trust? Like, is there a benchmark kind of thing that you say, all right, because of this, now we better look at a trust? Like, how do you know which way to go with that? I think you're muted.
I'm sorry. I hit the
That's
button
okay.
by mistake. It really comes down to when I'm discussing with the clients, kind of really delving deep into what their objectives are, what their goals are, run through some scenarios to see kind of, what their feelings are regarding what they ultimately want to see. I asked the client, when you're not here, how do you envision, your family moving forward without you? How do you envision your estate being distributed? And when they tell me, all of the different nuances of the family, I'm looking for all of these issues, and then I'm going to make a recommendation. So, and then it's up to them whether they want to take my recommendation or if they want to go a different route. But, or I give them various options as to what I would recommend based on what they want.
That's good. I have a Xerox machine running behind me, so I wanted to mute off for a second.
I have a dog.
Oh, you do? I didn't hear it. It's the joys of working from home. That's okay, because we're a dog-friendly real estate company, so I like hearing the dogs. Okay, so I wrote a couple of things to wrap up. Tell me if this sums up some of the thoughts that we had today, Tara. The first one, a simple will may not cut it for everyone. Number 2, consider a trust that leaves assets to your spouse for her lifetime, with the balance passing to your children on her death.
Mm-hmm.
Number 3, choose a sophisticated and experienced trustee.
Yes, that's definitely important. That's
important.
That's usually one of the biggest discussions I have is, all the other stuff people, seem to be able to agree on. And then when it comes down to deciding, well, okay, who's going to be in charge of the money? Who's going to be making distributions? Who's going to be the trustees for the surviving spouse or the kids? And that's kind of, the devil's in the details. That's when we really get down to analyzing the abilities of the family members and their ultimate, maybe motivations. And, we have to consider all of those aspects of the trustee and that role.
Yeah, because, I know in working with so many estate plans, like I do a lot of estate sales and working with them. So I talk to the one person, generally the personal representative, and sometimes the family members pop up. And sometimes it's just, did you guys want to help with any of this stuff? No, I don't want to help. I just want the money at the end.
Right.
I'm sure you deal with that all day long, don't you?
Yes.
That's why the trustee is critically important, choosing that trustee wisely.
Yeah.
Okay, and then the next one, plan for the possibility that your surviving spouse will remarry.
Yes, I mean, that's a big discussion. So especially with blended families.
Yep.
Or really anytime if someone's going to get remarried, because, it does happen when people remarry. And let's say they're married for 10 years after the first spouse dies, then, it is kind of natural for them to want to leave something to their new spouse, but then you don't want the first spouse that passed, their children, to be completely disinherited. So it's
so important. Oh my, Terry, I could go on and on with all these examples. Number 5, consider leaving some assets to your biological children upon your death. And that's, you touched on that in one of the first scenarios, that, if I die, here's some money immediately, and then maybe the rest go to the wife.
Yeah.
Okay. It's the poor man is always the one dying in all of our scenarios here.
I know. I always pick on the husband because, statistically, the men die before the women.
Yes, exactly.
Women survive like 10 or 20 years after they're gone. So I know.
Right,
Poor men.
right. Poor men. The next one, decide who will make healthcare decisions, right? We talked about that in one of our other calls too, how important that is. And I said that my father, when we were doing that for him, that was when he was in the hospital. He was facing a bypass surgery. And that is not the time while you're wheeling down a gurney to make these kinds of calls and these decisions and who's going to do what. So definitely consider that. And then the final one is hire an experienced estate attorney who handles wills and trusts. And obviously, Tara, that's what you do. And through all of these webinars that we talk about and all the scenarios, it's obvious, what you're doing, what you're talking about, and have been through so much. And I think that's really an important part, just like real estate. There's a zillion estate planning attorneys, and some of them are good and some of them aren't. So you just need to make sure that you click with the person, they're able to understand, and they're taking the time to understand their unique situation and to take you through some of these scenarios, that the what ifs. And I know we never go into a marriage anticipating that things will go wrong, but we need to anticipate that things could go wrong and be prepared to deal with that prior to, something happening, and just talking about it and making contingency plans. So choosing that person wisely. So if somebody needed to talk with you, Tara, about some of this stuff, how would they reach you?
So we have some really great resources on our website at frameandframe.com. And we've really been working hard the last year or so to get some guides out. We have some family protection checklists. We have a long-term care planning guide. We have a guide on wills, trusts, and probate. So there's lots of resources, lots of guides for you to download for free information, so that you can, educate yourself on these issues and become more informed. And you can always give our office a call, either for a brief call, or we're also scheduling consultations either via telephone conference, Zoom, or if you really want to see me in person, we will make accommodations. So obviously in a safe environment, but yes, we're available, and we'd love to help anybody talk about these issues and get their estate plan in place and get their affairs in order.
That's wonderful. Tara, thank you so much. We appreciate you. And next week we will talk about guardianships. And I think next week we have Erica on. Is that right?
Yes, Erica Rudman, who's the other attorney in our office, will be on that webinar. Both of us will be on, but she'll be answering most of those questions because she handles most of those cases, which can be difficult as well. So
yeah, that's going to be another big topic about when mom or dad can't make decisions anymore, what happens in that process. So I'm excited to talk with you guys about that next week. And until then, we will see everybody. Thanks for tuning in, guys, and we'll see you next week.
Thank you.
Thank you, Tara. Take care.